Wonderful. I think that's an excellent suggestion.
Very good.
Unless there's any further questions, I want to thank you very much for coming this evening.
Certainly welcome.
Thank you so much. Thank you.
Thank you.
Thanks very much. Okay. Comments from the public. Please.
Mr. Supervisor, members of the
Sorry, just state your name and address.
I was going to do that. This is Dick Hubert from 53 Doral Greens Drive. Mr. Supervisor, members of the Town Board, I noticed that on your resolutions tonight is the appointment of an official newspaper for the notices that the town publishes, and I do hope that you will modify that a bit to take into consideration the fact that we're more and more getting our official information on the Internet. And that in designating any kind of official outlet to distribute key town notices and ads, that it be a newspaper that can link free to the town, where the readers can access those easily. I think that I would suggest that you have town notices that are not just on the town website, but perhaps on other websites that service the town, as well as newspapers, so that everyone gets a chance to see the notices, whether they subscribe to that particular newspaper or not. And that's a suggestion I hope you can think through tonight. Thank you.
Thanks very much. Mr. Noto, what is the import of the designating the official?
You have to have a newspaper for your bonding and your legal notices and advertisements. So you have to designate at least one, usually two, newspapers as your official paper. And you can have more than two if you want as well. I mean, there's no.
Okay.
But it has to be a newspaper. So far, we haven't caught up to
So there's
cyberspace.
I see the journals from patch.com here, which is a new electronic site.
And they're not a newspaper because they're not on
Right.
paper, so they wouldn't fit the definition. But you can certainly designate them as an entity that will get your notices.
Okay, well,
Things
certainly
that
as a
they
matter
have
of policy, I think that's a wonderful suggestion. And as a matter of policy, Town Clerk Vespi, if you could make certain that all our official notices go to all the local media, whether it be officially designated or not, including the electronic media. Other comments from the public? Okay. We've got a pretty heavy agenda tonight, so let's move right into that. Mr. Markowitz, we have an outstanding certiori. I think we've seen this a couple of times, correct?
That is correct. This is a certiorari involving several properties in the village of Portchester. It spans multiple years. We've discussed it before. It's a resolution to resolve outstanding certioraries for many years.
15 years.
Yep. From the mid-'90s.
We've been through this before, correct?
Correct.
Anybody have any questions on it? Okay, can I get a motion to approve?
Motion to approve.
Second?
Second.
Guilford.
Aye.
Mendocino. Ayers. Villanova.
Yes.
Corbin.
Yes. Thank you, Mr. Markowitz.
Thank you.
Mr. Noto.
You should have in your packets a memorandum from me that was dated December 29th on certiorari legislation, and attached to that memorandum was a proposed resolution, which was not in your packet, but then we reproduced it, so it should be in front of you. The issue is as follows. As you know, we get about 200 certs a year, primarily from commercial entities. And the supervisor, as we also know, has been extremely aggressive in addressing the cert problems. And he has asked myself and Mr. Markowitz to devise various strategies to cope with these certs and to try and reduce the number. And beyond the legal department, there are things, as you know, we're updating our values this year. Mitch has been very helpful in identifying some of the more egregious cert cases where we've seen claims that really are beyond the pale. Our special counsel who handle our cert claims, Aldo Vitigliano, Jeff Binder, and Mark Toulis, have also been very helpful in moving some of these cases along. But we've learned through this process that the state law is really not, municipality friendly. It does not make it easier for municipalities, and in particular, a municipality that has undergone a revow. In fact, the existing state law provides a disincentive for communities that have a revow, which takes us to these proposed changes. Last summer, we initiated a conference call with ORPS, Office of Real Property Services, and their legal counsel. And ORPS is a part of the executive branch of state government. Their counsel were very nice, Joe Gerber, and we had about an hour-long conference call with the supervisor, and Mitch was on it as well, myself, and we discussed some proposed changes in the state law, which would have a statewide impact, that we think would be helpful to all municipalities, but obviously right town. So, Council to ORPS came back with these proposed changes, and I'll go through them with you. The first one is we are proposing a change in Section 718 of the RPTL, that's the Real Property Tax Law. And what that does is it will give us the opportunity to advance a case, meaning file a note of issue to get the case faster in front of the judge. Right now, the petitioner, the people that are filing, are basically holding the cards, and they are the ones that initiate the acceleration of a case to adjudication. The cases are supposed to be adjudicated within 4 years. And what this, if this change is adopted, it would give us the opportunity to bring it forward, within any time between 6 months and 42 months of the action, which would accelerate the whole process. Now, obviously, there's an argument to be made, since most municipalities settle certs, and when they settle, it means they're reducing assessments. Some communities don't want to accelerate these; they want to just let them languish for years and years until they have to pay the piper at the end. This supervisor would like very much to get these things adjudicated quickly, which also provides predictability for the town. You know what your exposure is financially, and it certainly can clear the backlog of certs. I mean, we know that having done a reval in 2004, one of the attributes allegedly of a reval was to reduce, if not eliminate, certioraries. We know from experience that that is not the case. However, we think that with our new updated certs, with our new updated values, we should be able to at least identify those properties where there may be some issues. We can address them faster and eliminate the need for a cert. So the first proposed change is on that particular issue. The second one is on Section 720, which is relevant to Right Town, because as you know, we adopted last year an I&E law requiring all commercial properties to submit income and expense information. What this change would permit would that the case could be dismissed at the state court level, if the commercial entity did not file the I&E and did not comply with our law. Currently, we only have local enforcement jurisdiction, meaning we can reject the cert claim at the board of at the VAR level, at the assessment review level, but the state court is not bound by that. So if this were enacted by the state legislature, any community that had an I&E law and a cert was filed without the I&E information, that cert could be dismissed, at the beginning of the process.